Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. We are here for a special Zoom hearing of two cases. I'm Judge Milkey. With me somewhere on the screen is Judge Henry and also my colleague, Judge Walsh, and we are your panel for both cases today. The ordinary rules of the appeals court apply in terms of 15 minutes per side, no opportunity for rebuttal. We want to assure counsel that we have read the brief, so we're familiar both with the facts and the arguments, so we therefore urge you to cut to the chase to the extent possible. On the other hand, if you feel you have made your points, there is no shame in ending your argument. As one of our former colleagues used to say, if you hit a home run, there is no need to run the bases twice. And with that, I'm going to call the first case of the morning. That is 2020 P743, Commonwealth versus Jose Santiago. Attorney Fellows.
Good morning, Your Honors. Michael Fellows for Jose Santiago. I would like to focus my remarks today mostly on the motion to suppress. And if there's time at the end, perhaps a little bit on Collins. But our argument essentially is that the motion judge in this case failed to consider the totality of the circumstances in what are really two separate eyewitness identification procedures. And she essentially lumped them together into one and analyzed them as one. And by doing that, I missed or misapprehended certain important facts. And those mistakes led to errors of law. So I want to deal with them each separately. The first is the identification of Ana Lucerna. She was first shown an array at her own home with the first array. I believe it's on page 130 of the government's appendix is the best picture. And in that array, the defendant is shown wearing no shirt, and he is the only person in the array wearing no shirt. Now, in her decision, in her ruling, the judge in the facts section makes mention of this, but she does not analyze it in the rulings of law. What effect did this first array have on the second array? She did not analyze whether it was unduly suggestive, unnecessarily suggestive. She didn't discuss the impact it might have had on the viewer, and she did not discuss its import as to the second array, which from our perspective is crucial. This is part of the totality of the circumstances. In her comments during the motion to suppress hearing, it appears that she seems to think that the first array is irrelevant. What she says at one point is she'd understand and appreciate the argument better if they had selected pictures from this first array, but they didn't. So why are we talking about it? Well, we're talking about it because the first array draws the eye to the defendant, Santiago. And that has to be considered when we're looking at the second array. So then the second array is put together. And here the judge makes an erroneous finding of fact. She says that Sergeant Savine, I believe is how it's pronounced, compiled the second array because he found a more recent picture of Jose Santiago, which is not the case. There's no evidence, there's no testimony that that's what happened. There's no evidence that that's what happened.
But counsel, if she had just said she found a different picture of Santiago, would that change the analysis?
No, I don't think so, because I think what the case law says is that if you're going to do a second array, you have to have a good reason for it. And a good reason, as many of the cases say, is if the defendant's appearance is changed in some way from the initial viewing to the second. If there's no difference between the two, there's no essential difference between the two, then that doesn't make for a good reason to show a second array. Second arrays are inherently suggestive. Case law is very clear about that. And the case laws, most of the cases have said, just because there's a second array doesn't automatically mean it's unnecessarily suggestive and we suppress. But here we have first an unnecessarily suggestive array, which influences an unnecessarily prepared second array. No analysis of how the first array affects the second array, and no discussion of whether the second array was necessary. And this is part of the analysis. Is it unnecessarily suggestive?
You're saying that the first array, him having no shirt on, was problematic, and the second array cures that, doesn't it?
No, I don't think it cures it in any way, Your Honor. I think that what you have in the first array is a picture that focuses the viewer on the person not wearing a shirt, and then you have, as the only person who shows up in the second array, the person who wasn't wearing a shirt. So if we think that the person who's the witness has a memory good enough to remember what they saw on the night in question, we should probably also assume that they have a memory well enough to remember the people that they saw in the first array. In fact, there is some case law that suggests that it's okay if there's more than one person from the first array in the second array, because then we're not just looking at one person. But here we're highlighting one person. First, we're highlighting them in the first array without a shirt. Now we're highlighting them here because we're showing them in a second array without any reason at all, certainly without a good reason. And I think it's important to note that there's absolutely no reason given for the shirtless array in the first place, which seems to me to be highly problematic. I mean, the police at this point should understand that the decisions coming out of the Supreme Judicial Court and this court are highly skeptical of eyewitness identification procedures right now and are looking at them, scrutinizing them in detail, and just putting a picture in of a guy not wearing a shirt without any reason whatsoever is
Counsel, what standard of review applies to our review of this particular issue?
Well, this is a constitutional issue, so the court, I believe, the standard of review is essentially de novo, that you can review when you accept the lower court's findings on credibility, but that issues of fact and questions of law are for this court to re-examine. And I can pull out the case that says that. I believe it says that right at the beginning of my brief. So
So you're saying we give no deference to the motion judge in his determination that this was not overly suggestive?
I'm not saying that you give no deference to that, but deference is minimal. If the judge has clearly made an error of fact or law, because this is an issue of constitutional dimension, this court has the authority and indeed the duty, I think, to review those findings and to make its own findings on everything other than any findings about the credibility of a witness at the hearing. So one of the things that the judge then didn't do in the second.
Do we consider at all that in the first array, he actually looks more like several of the other pictures because they have facial hair, but a couple of other people don't have facial hair? So in that way, he's more like the majority than he is like the couple that don't have facial hair.
Your Honor, I'm sure we could go through and find ways that he looks similar to other people in many ways, but the fact is that he is not wearing a shirt. It's very apparent. And I think from my perspective, that stands out. When I first looked at it, it looked odd to me. Why is he not wearing a shirt? Why is everyone else wearing a shirt? Why is he not? And I think that would happen to anyone who's looking at it. It seems like an odd thing for a photograph from the police to have of a man without a shirt on.
So
and it's
what
certainly
we're
distinct
supposed to be
from the other
considering
people.
apologies, we're supposed to be considering reliability here, right? That's the concern with eyewitness identification.
Well, there's two parts. Yes, there's reliability, but there's also the inherent suggestive or unnecessary suggestiveness, which leads to the possibility of an irreparable, I guess, unreliable identification. I mean, when the motion to suppress, we're talking about due process issues. So it's not entirely reliability, but that is important, yes.
Is he in fact the father of the person who was supposed to fight?
Yes.
So,
Yeah.
And you would agree with me, counsel, that, I mean, this case has nothing to do with identification as it involves a person with a red shirt or a blue shirt. I mean, there's nothing about that, along with the fact that they already know him.
They don't know him. They make very clear that they do not know who he is prior to this evening. They've never seen him before. They make no descriptions of him when they first talk to the police. They offer no descriptions of them. They say they have maybe know his wife. So they may know of him, but they don't know him. So it's not like they've seen this guy before and, oh, here he is again. As far as the distinguishing feature goes, I think Arzola says that having a distinguishing feature is okay when it is clear that the victim did not select the photo based on the distinguishing feature. And in that case, the victim or witness specifically said that they identified the picture based on the person's face, the tone of their skin, their eye color, their hair, specifically mentioned those things. And I think that was the gray shirt. In this case, we have nothing from the witnesses that say why they picked him, other than, you know, they say he's the guy. But this is after the first witness has been shown a shirtless picture of him and then given a new array for no real reason, where he's the only person who reappears. And I've seen many cases where you have multiple arrays and many cases where you have a distinguishing feature, but I've never seen one where there's both. And in our view, these two stack and accumulate to create a due process problem. Now, as far as Cologne,
I was just about to ask, was one of the witnesses only shown the second array?
she was, and in this, I think it's even clearer that the motion judge did not consider the totality of the circumstances. Contrary to what the Commonwealth says in their brief, we are not just arguing that because it wasn't videotaped and because there wasn't a blind or double blind presentation, that this fails Silva Santiago. What we're saying is that the entirety of the interaction is problematic. What you have is an initial reading of the Silva Santiago protocols, and then a going through the pictures, and then the officer, his uncontradicted testimony, credited by the motion judge, puts the pictures to the side of the desk and speaks to the witness for 40 minutes with those pictures apparently on the desk in full view, because at the end of that 40 minutes, he asks her if she would like to view the array again. And instead of him picking out the pictures and doing the array again, or getting someone else preferably to do it, he just watches her as she reaches over and slides a picture out from the pile, which seems to imply that those pictures are visible the entire time, because she knows exactly which one she's pulling out and sliding. She slides it across the desk and looks at him. Now, this seems to me to be the most suggestive possible sort of situation, but we don't have a videotape of it. So that is a problem, because we have no idea whether he gave her a look knowingly, unknowingly, intentionally, not intentionally, a confirmatory look. It seems hard to imagine that she would just look at him and he would be completely stone-faced. I've never played poker with him, but my guess is that he was not. But the issue is the judge doesn't analyze this at all. She simply says that the second showing to Ms. Cologne did not taint the identification. Well, there is no second showing, really. There's a first showing, and then there's the picture sitting on the desk for 40 minutes, and then her selecting that picture out on her own, which I don't think in any of the cases I've read fits any protocol anywhere. And I'm pretty sure the social science would say very problematic, because when you're having silent communications, when people are looking at officers for feedback, which is apparently what she's doing, that's when we have the kind of suggestiveness that creates unreliable identifications. And there is no reason given for it. Again, there's no reason given for this, for why he did this. There's no reason given for failing to record. The courts say it's not necessary because sometimes it's not practicable. In this case, it was entirely practical. They're in the station. He says he has the ability to record. He just doesn't do it. And in a circumstance as odd and suggestive as this, I would suggest that the court should require that there be a recording, so that the court can analyze exactly what happened. And if not, that the police should not be given the benefit of the doubt that everything was just fine when it seems really to not be fine at all.
Counsel, I do have another question. You talk about that there may have been an error on the timing of the two witnesses and the victim viewing the videotape, that they may have viewed the videotape before they did the identifications, right?
Yes, yes.
And you said, that if we were to follow conventional human experience, that they talked while viewing the videotape. But where they didn't know the shooter in advance, what influence would they have had on one another when they viewed the videotape together? I'm trying to understand what the conversation would be that would be concerning for you.
Any conversation would be concerning for me, but they're watching a videotape of an event that was very important, that was distressing, that affected all of them. And the idea that they didn't speak to each other at all is odd to me. But if they looked at it several times and started to agree as to who this person looked like, and they're looking at a video that actually doesn't necessarily show, from the video, what you never see Mr. Santiago fire a gun. So is this confirming to them the things that they think they saw that maybe they didn't see? Maybe they saw him move, but that doesn't mean that he fired any shots. But if they're talking to each other, that increases their confirmation bias itself. That by itself makes them feel more confident. So if they think, oh, that's the guy, oh yeah, that's definitely the guy, that is a problem when they're talking to each other.
But I'm confused because, you're saying that the conversation may have identified their actions during the photo array. And I'm having a hard time imagining what that conversation would be like. Oh, it's the guy in the picture with this kind of shirt doing this, and it's all black and white.
Well, but my concern about their discussions of the videotape is really in regard to the Jones analysis, because it doesn't come up in the motion to suppress. So that information isn't available there. But
there's no evidence either that any of them spoke to one another, correct?
There's no evidence. I believe that if any court was to, if a prosecutor was to ask a jury to infer that three people who knew each other, who were family members, had watched a videotape and spoke about it to each other, that any appellate court would find that that was a reasonable inference that one can draw. It's very hard to imagine that they would not speak to each other in any way, but they wouldn't have to speak to each other to create confirmation bias. They just look knowingly at each other. That in and of itself will do it. It doesn't take a lot. As we know from the social science, memory is not a tape, it's a construct. And we put it together based on the things that happened between the event that we saw and the time that we talk about it. And anything that happens in between that can affect and alter our memory.
Okay, counsel.
Test after test shows this.
Counsel, your time has expired. Let me check with my colleagues to see if they have any further questions. Hearing none, you'll have to rest on your brief for your remaining issues, and we will now hear from the Commonwealth.
Thank you, Your Honor.
Good morning. May it please the court, Assistant District Attorney Lee Baker on behalf of the Commonwealth. I'd like to start by addressing a question that came up during opposing counsel's argument as to what the standard of review on the motion to suppress is. Now, the standard of review is that in reviewing a judge's ruling on a motion to suppress, the reviewing court gives substantial deference to the judge's ultimate findings, and it accepts the judge's subsidiary findings unless they are clearly erroneous. And that comes from Commonwealth versus Santana. That's a 2013 SJC case, which I reference on page 49 of my brief. And I would also like to address one of the questions that came up. I believe it was Justice Walsh had asked if it were not the case that the witnesses knew the defendant, and opposing counsel said no, they had never seen him before and gave no description. I'd have to quibble a little bit with that. It is correct to say they had never seen him before that incident, but they did in fact give a very detailed description of him on the night of the incident. What's most germane is that the individual who was Damien's father, who had come to the fight to intercede, was wearing a large gold medallion. All of the witnesses testified to that. Suarez, the victim in the case, testifies to the man wearing the gold medallion saying, you should get shot. Lucerna, I believe, testifies that she hears the man in the gold medallion say, you deserve to be shot. Lucerna sees the man with the gold medallion pull what she recognizes as a 9mm handgun and fire it in the direction of the victim. So when they did the identifications later, there was already some description that had been given of him with regard to the medallion and so forth. Why that's important is because you have to consider these identifications, as the motion judge did in the motion for new trial, in terms of their reliability based on the circumstances. And the motion judge was also the trial judge, had said that, there was very strong circumstantial evidence that supported their identifications. And in particular, because the defendant was in fact the man wearing the medallion. And since they had to identify the man wearing the medallion, those dots were easily connected. Now, why does the motion judge say that the man wearing the medallion was clearly the defendant? The defendant admitted that he was there, that he was wearing the gold medallion, that he was the father of Damien Gonzalez. So the defendant put himself there, dressed in that manner. All that really those identifications do is then tie that together with the witness's testimony that they saw the man in the gold medallion fire the shots.
So, counsel?
Sure.
That's all incredibly helpful. I just want to make clear, though, we do have some factual findings that are clearly erroneous, correct?
Well, which in particular do you mean?
You conceded a couple in your brief, I thought. In
right,
fact,
there was, for example, this may be what you're thinking of. The motion judge for the motion to suppress erroneously said that Savini included assembled the second array because he had found a newer photo. Now, what I concede is that there was no testimony from Detective Savini to that effect. Now, I do make an argument that that's not clearly erroneous insofar as the judge could have inferred that by looking at the two pictures and thinking that the RMV photo that was in the second array looked like a newer photo. but also it's important that the defense motion sort of parses out what the judge found there. And she found not just that Savini created the second array because he had a newer picture, but also because, quote, he felt it prudent to reconstruct the photo array since he had failed to warn the victim and the witnesses to refrain from discussing the case.
Right,
So,
but wasn't the other,
yeah.
Isn't there an issue about the timing of when they received a video of at least some of the incident?
Right, so that's correct.
For the record, I'm still here.
that goes to the motion for new trial. That's correct. The motion judge on the motion for new trial did erroneously find that they did not see the video until after the identifications. That was incorrect. However, that was not essential to his findings.
How do we know that?
So he, let me pull up the language from his ruling. Pardon me for just a moment.
Counsel, perhaps we should.
Yes, sir. Yeah, I apologize. But his main point was not that it was untainted by seeing that video, but rather that it was not unduly suggestive and that it was reliable. So he said that there was no evidence of any discussion between the parties about the identifications, which is correct. There was nothing in the record to suggest that. There was no testimony at the motion for a new trial from those witnesses to suggest that they had, in fact, had any such discussion. Yeah.
Counsel, I mean, why isn't your brother correct that if three people who just witnessed a traumatic event and are all related to each other are viewing the video, that they're not going to talk about it? Well, they are going to talk about it.
Right. Well, I mean, that's a reasonable inference as far as it goes, right? But there's a further step or two necessary to get to where the defendant wants to get. The mere fact that they would have discussed the case, which, I mean, one can assume, absent the video even existing or them ever seeing it, that they would have had occasion to discuss the case prior to trial. We don't sequester witnesses for the entire pendency of a case. What really is incumbent upon the defendant to show is that any discussions that they may have had would have been such that they would have influenced that identification. And what's important with regard to that, right, is that Lucerna sees she's the one who sees two arrays. Lucerna is at the victim's apartment, Suarez's apartment, when Detective Savini goes there. And Detective Savini shows the array to the victim. He's unable to make an identification. Lucerna looks at the array, asks to look at it, looks at it, but then declines to make any kind of identification.
And but counsel, why? Yeah. I mean, why isn't it that the Commonwealth therefore is just stuck with the lack of her pretrial identification with the first array? Why do they get to show a second array and include a different photo of the defendant?
Right. Well, let me deal with those each separately. So first, why do they get to show the second array? The second array was compiled to show to Cologne the following day when she came down to the station. So that array was not compiled to show Lucerna a second time. That was compiled to show Cologne. And in the time between the array which he showed to Suarez and the array that he showed to Cologne, Savini had reason to have second thoughts and think, well, maybe I should have a different photo in there. And so he uses the RMV photo. So when he's compiling that photo, he doesn't do it to show a second time. How he ends up showing it a second time is that Lucerna goes down to the police station to give a statement. When she gives her statement, she becomes very emotional. And she essentially says to Savini at that time that she's scared of the defendant, that she would have been able to identify him in the array the first time, but didn't because she was afraid of him and afraid of retaliation from him. And she asks to be given a second opportunity to view an array because she feels she needs to, quote, do the right thing. So this is—
But then do they show her the first array or the second array?
He shows her at that point that second array that he had compiled. So he didn't compile it with the intention of showing it a second time to that witness, and he only shows it to that witness on her asking to be shown it. And, you know, as far as the shirtlessness goes, I think it's important to note that all the cases involving a difference in the photograph of the defendant, that difference goes to something relevant to the identification of the defendant. What I mean is, for example, the witness says that the defendant, their assailant or whomever, was wearing glasses, and then they're subsequently showed an array where only one person is wearing glasses. Or they're told that, you know, the person was wearing a gray shirt, they're showed an array, only one person is wearing a gray shirt, right? In this case, yes, it's a distinguishing feature that he's shirtless, but that shirtlessness has nothing to do with the initial observations that those witnesses made at the scene of the crime. It would be a very different case if he was shown in a photograph that pictured him with his trademark medallion, for instance. That would be highly prejudicial and certainly unnecessarily suggestive. And it's also worth noting that in the case in which there was some issue because the defendant had been described as wearing a gray shirt and then the array only had a person with a gray shirt, they still found that not unnecessarily suggestive because it wasn't the focal point, and the shirtlessness is not the focal point of this photograph either.
So am I correct, and I may be wrong because I have to say actually this was a little confusing in the briefing, that both Cologne and Lucerna said the man in the medallion did the shooting, and then said the defendant was the man in the medallion?
Well, so both Cologne and Lucerna described the person who did the shooting as the man in the medallion.
And the defendant admitted he was the man in the medallion.
He did. He did. And there's an identification that wasn't contested that came from Detective Jennifer Sattler of the Holyoke Police Department. Now, Jennifer Sattler had known Mr. Santiago for about 20 years prior to investigating this case. And she's the one who did the interview with him. And at trial, when the video of the defendant's statement was introduced, she identified Mr. Santiago as the man in the video from the scene of the crime, because you don't ever actually see the man with the gold medallion's face in the video. It's a handheld phone video that's very wobbly. You see the medallion and those kinds of things, but you don't get a clear view of his face. But Jennifer Sattler ties him in that way. And of course, he ties himself in. He puts himself there. He puts himself as the father of one of the combatants, and he admits to having been wearing the medallion that day. So even if it were the case that these identifications had been suppressed, the Commonwealth still had a very strong case without them.
Okay, so is the defendant correct that at no time did a motion judge or the trial judge determine whether the shirtless photo of Santiago in the first array did or did not render that array unnecessarily suggestive?
I
Yeah.
I honestly don't recall for sure. It does seem to me that in their analysis, neither lingered too far on that point, because in the motion for new trial, the motion judge, who was also the trial judge, he felt that that was sort of inconsequential, because overall the identifications were reliable given the circumstantial evidence apart from them.
Do either of my colleagues have any further questions? No. We'll have to leave it there then. Thank you both very much. The case is now submitted.
Thank you, Your Honors.
The case is now being recorded.
Thank you very much. We are back online for our second and final Zoom hearing of the morning. The next case is 2019 P1624, and that's Commonwealth versus Booney Lakong Feng. I just want to remind the parties that we have read the brief, so we're familiar both with the facts and the arguments. So I would urge you to cut to the chase to the extent possible. And we will hear first from Attorney Lindmark.
May it please the court, my name's Attorney Pamela Lindmark, and I'm here arguing on behalf of Mr. Booney Lakong Feng. It's our position that his defense was materially compromised, prejudiced by the repeated and unnecessary introduction of gang-related evidence throughout the entirety of the trial, and furthermore, that the trial judge's attempt to mitigate that prejudice was inadequate. As well as outlined in issue 2, the court testimony presented by the Commonwealth witnesses seemed to vary from date to date, hearing to hearing in such a material way that not only the credibility of the witnesses was drawn into question, but also the very foundation of the Commonwealth's case. Now, as to issue 1, we're questioning whether the repeated introduction from several witnesses and then again in closing arguments of gang-related evidence so prejudiced the defendant's case as to outweigh any probative value of that evidence. We would suggest yes. Now, on pages 18 to 22 of my brief, I've outlined pretty much my understanding of who testified to what regarding the gang-related testimony. The analysis we suggest is twofold. Number 1, is gang membership relevant to this case? Yes, it is relevant, but only minimally so, and only to show the motive of the actors here. However, as in most of the recent case law, we see that great caution is urged in admitting such evidence. It is critical to avoid the risk of unnecessary prejudice to the defendant. I've cited in my brief, for example, Commonwealth versus Akara, a mass SJC case, establishing or declaring that community attitudes toward gang violence are likely to color such evidence. And in simpler terms, jurors hearing someone is or was or could be a member of a gang may assume that individual is violent or criminal or worse, independent of the actual evidence. And that's the danger.
Counsel, I may be jumping too far ahead, but why didn't the instruction that the judge gave cure the problem? Because you've conceded, as you must, that it is relevant, for the jury to hear that this was a potential motive. This wasn't an attack that came out of the blue. And the judge did instruct the jury about the limited use that they could make of this.
She did, Your Honor, and it's our position that according to the most recent case law, the standard practice is to conduct an individual voir dire of all potential jurors prior to the trial. This is what distinguishes this case, and we feel this is the most important aspect of our argument in issue 1. Did she question the jury? Yes.
In reviewing the cases, it does seem that at least more of them than not do the individual voir dire, but is there a case that requires it?
Not to my knowledge, Your Honor, but I'm suggesting today that there should be, and this case in front of us could be such a case.
And why would individual voir dire matter? And I ask that because we're not asking someone to disclose something that might be personal or embarrassing. Like, I could see why you might not want to ask the entire panel, have any of you filed for bankruptcy? This seems like a different inquiry.
It is a different inquiry. It is possibly not as private as the other cases you're suggesting. However, the possibility of prejudice to the defendant's case is central to our argument and central to his constitutional right to a fair trial. There should be careful questioning of potential jurors individually to ensure that they could be fair and impartial. I'm
trying to understand what particularly on this issue would make a difference between asking the entire potential panel or asking someone individually.
Asking someone individually, one-on-one, Your Honor, we would suggest is a more in-depth approach, a more likely to draw forth any potential prejudice. The individual jurors probably would be more likely to admit that to a judge face to face, as opposed to sitting in a big room full of other potential jurors and maybe not wanting to raise their hand and say, yes, I am one of those who would be affected by this. And again, we're dealing with such a basic constitutional right here. A man's liberty is and was on the line, and it's important to cover all of these important bases.
So the Commonwealth argues that even if at least the full quantity of the gang evidence had amounted to an abuse of discretion, that it really wouldn't make a difference because of the unequivocal identification of the defendant by 2 different eyewitnesses as the perpetrator of this brutal attack. What do you say to that?
Well, 2 things. First of all, it does make a difference. We need to protect individual defendants' constitutional rights, no matter what we think might happen in another scenario. It's a question of the law. But also in issue 2, we're making the argument, and in fact, that there very well could have been a mistake in the identifications. And the evidence in this case was variable at best. And in some, unless there are other questions, again, we're arguing that she should have conducted these individual voir dires. She did not. There was all sorts of evidence we're getting from many different witnesses regarding gang evidence, which should not have been admitted. Palpable error was established, and this reviewing appellate court can and should reverse these convictions. Now, as to issue 2, Your Honors, I'm willing to rest on my brief.
Just on the issue 2,
yep.
You point out accurately that there's some conflicting evidence here. But isn't the case law clear that is not enough on sufficiency? It's the job of the jury to sort out the conflicting evidence and to find the facts.
It is the juror's job to decide who they believe, who they don't believe, and so forth. But it's also the judge's job to be the gatekeeper, in a manner of speaking, to recognize when something is just so improbable, when it's impossible to establish beyond a reasonable doubt who did what, then it would be the judge's job to step forward and make that decision.
Okay. Do either of my colleagues have any further questions? No, hearing none, we will thank you very much. We'll now hear from the Commonwealth.
Good morning, and may it please the court. My name is Melissa Johnson. I'm an assistant DA from Middlesex here on behalf of the Commonwealth. As to the first issue, I would point out, or I would disagree with my sister, that this was only minimally relevant. We know from the facts that the defendant said to the group right before he brutally attacked the victim, he asked them, "Are you AB?" So we know right there that motive, the primary motive of this was a gang hit. And so, the judge did not abuse her discretion in deciding that some of that gang evidence was highly probative and that outweighed any kind of undue prejudice to the defendant. And she did her best, and I think she did enough to minimize any undue prejudice. She did vet the jurors. When she questioned the venire, she actually asked them 2 different questions about their impartiality in the face of gang evidence, and also if they had ever been personally affected by gangs or harmed by gangs. So she asked them 2 questions there to try to vet out whether they could decide this case impartially, and there were no affirmative answers. She also gave the jury a very...
counsel,
yes. Yes, Your
in
Honor.
looking at the many, many cases that deal with these issues, the individual voir dire is overwhelmingly the practice.
I wouldn't say overwhelmingly the practice.
Well, then I'm going to ask you to give me some examples where there was an individual voir dire.
Well, I can give you...
They were hard to find.
Well, I can give you 2 off the top of my head. In fact,
Okay,
one
great.
that was cited by my sister, and that's the Arcara case. And I apologize because in my brief I said it was note 13. It's note 14 where the court does talk about the fact that the question was posed to the venire. And then the FIM case, which came out of Middlesex County, that's at 462 Mass 470, where the judge questioned the venire. I have to say, I just don't see where an individual voir dire in these circumstances is absolutely critical, as we might do in other cases where, for example, if it's a sexual assault, child sexual assault, or a cross-racial sexual assault, where a discussion at voir dire, individual voir dire at sidebar might be more appropriate. I don't really see how in this particular case, and the courts have never ruled that in this type of case, that it's absolutely required. And as I said, in addition to that, in addition to those questions, she did instruct the jury and gave a very comprehensive instruction to the jury that this evidence really goes to the state of mind of the defendant, doesn't go to his character or propensity. So I really do think that she went above and beyond to minimize any undue prejudice. But at the end of the day, this was highly probative evidence. We know what the defendant said to the group beforehand. And there was also evidence that the victim himself was a member of a gang. So it kind of cuts both ways. And there's really no other way to explain this otherwise inexplicable act of brutal violence against the victim, but to have some gang evidence in there. And the Commonwealth is entitled to paint a full picture of this incident as possible, as long as the judge is taking steps to minimize the prejudice and to ensure that the jury is considering this evidence in the light that it should be considering it, and not just prejudicing the defendant. So
was the evidence that the victim was currently a member of the gang or had formerly been a member?
The evidence was that he formerly was a member of the gang, and that was from his uncle. And the defendant, his testimony came through grand jury, and he appeared to say in grand jury, because he wasn't willing to testify at trial, that he had been a member. And apparently a couple of years ago when he had his daughter, he decided to renege his affiliation with the group, but he had been a member at some point, according to the evidence. And so for that reason, that was important to kind of play out the rivalry between the two groups. If there are any further questions on the gang affiliation evidence, I would just move on to the sufficiency of the evidence. I won't spend a lot of time on that, except just to say that I would echo what Justice Milkey pointed out as far as the credibility findings of a judge. And a required finding is simply not appropriate for a trial judge to be weighing in on the credibility. I think those issues came out in cross-examination very well by the defense attorney, that there were some conflicts, but certainly when you have a case where there's two unequivocal identifications of this defendant right after the incident, we had a pretty solid case here. So I really don't think that either the gang evidence or the sufficiency of the evidence is enough here to reverse the defendant's convictions. And for those reasons, unless there are any further questions, I'm happy to answer them. I would ask that this court affirm the defendant's convictions.
I see no further questions from my colleagues. Thank you both very much. The case is now submitted.